everyone, it's Anthony Bandiero here, attorney and senior legal instructor for Blue Gold Law Enforcement Training, bringing you another roadside chat. This question comes from an officer in Nevada. He says, it involves a search incident to arrest of a backpack or a purse or something similar. Does the Nevada Supreme Court decision in State versus Nye prevent police officers conducting a search incident to arrest of a purse or a bag? If an officer does conduct this search incident to arrest, does the arrestee have to be immediately next to it, right? Or do we have to just do an inventory? Okay, what the heck is this officer even talking about? He's talking about a case from 2020 where essentially here's what happened. An officer arrested Nye, I think for a warrant, okay? She had a purse. He takes her to, he arrests her, he takes her purse, he puts the purse into the back of the patrol car. He takes her to jail, books her in, and then he searches the purse. And when he searched it, he found some narcotics. What did he call that search? He called it a good old-fashioned search incident to arrest. Do you see the problem? Do you see the issue that the Nevada Supreme Court brought up by calling it a search incident to arrest? The problem is that when search incident to arrest is supposed to be contemporaneous, right? At the same approximate time of the arrest and within the proximity of the arrest. This was neither proximate to the arrestee, it was at the jail while she was in the holding cell, and it was not contemporaneous. So it really wasn't a search incident to arrest. It could have been an inventory, but here's what the court said, essentially. They said, the Nevada Supreme Court says, the authority to search incident to arrest derives from the need to disarm and prevent any evidence from being concealed or destroyed. Here, the search occurred after the officers arrested Nye, secured her inside a patrol car, put her backpack, not a purse, into the trunk, and took her to jail. Thus, at the time of the search, Nye did not pose a threat to officer safety, nor was there an immediate need to preserve evidence because she had been and remained separated from her backpack. Accordingly, this was an invalid search incident to arrest. So, what are we supposed to do? We're supposed to inventory these bags. Now, the officer did say, what if it's like quickly, right after? And that's probably not going to work either, not in Nevada. And here's the reason why. Is because the arrestee is almost always going to be in handcuffs. Therefore, there's likely no possibility of access, right? So we still don't have this need to disarm, to prevent evidence from being destroyed and so forth, because they're secured. It's going to be a very rare situation. It could happen, but it's going to be a rare situation when an arrestee is able to grab the backpack. So in Nevada, what I teach, and I teach in Nevada a lot, is look, search incident to arrest of that backpack, it's over. Put a fork in it. Instead, call it an inventory, right? And that can be done on scene, or you can wait till you get to the jail to do that inventory. This is also not very, this situation is something that is coming about around the nation because of the actual scenario that we're talking about here, because of a case called Arizona versus Gant. What happened there is that the police searched Gant's car incident to his arrest for a warrant and no license. His car was not going to be towed otherwise, okay? It was in his driveway. And the court said, look, that is not a valid search incident to arrest of his vehicle because even though he came out of that vehicle and he was arrested from that vehicle, there's no way for him to gain access to that vehicle. Right? He's not going back in it. He's not near it. He's in handcuffs. In fact, he was cuffed and stuffed in the back of the black and white. So that's probably done as well. So this whole idea, that applied to cars. But there are other courts out there, the 4th, the 10th, Nevada, and other court cases, courts that are saying, you know what? Gant doesn't just apply to cars. That logic of it has to be accessible also applies to backpacks and purses and so forth. So we need to probably just call those inventories to be safe. The only issue I will say, though, since we're on the topic, before I let you go, is what are you going to do if a person gets arrested for a warrant? So let's say you see the person walking down the street and they have their backpack on their person. They have a warrant for whatever. And right next to them is their spouse. And the cop says, hey, you're under arrest. The backpack is taken off of him. It's put on the ground. And the arrestee tells his wife, hey, take my backpack. And the wife, of course, is willing and able to take the backpack. She's on scene. We don't have to call anybody. Nothing ridiculous like that. What are you going to do then? See, if you're in a state that still upholds a search incident to arrest in the old-fashioned day, the old ways to think of this, then you could search anything that was in their possession, right, that they controlled or in immediate possession at the time of the arrest, which is, hey, you're under arrest, take off the backpack. But now that we have cases like Nye and some other cases like Davis, I think that was from the 4th Circuit, maybe from the 10th. But anyway, but now that we have cases saying, wait, hold up. At the time that you actually searched it, where is the arrestee? Well, in my situation of the guy being under arrest for the warrant, he's probably cuffed and stuffed in the black and white or near there. Does he have any reasonable likelihood of access to that backpack? And the answer is going to be no. Now you look at inventory. Some cops will say, Anthony, it's fine. It's going to be okay because I'm still going to take that backpack to jail. But I say, well, what is your logic there? What, when you inventory things, it's for basically under community caretaking. You are trying to help them, help us, so we don't get accused of stealing their property. But they have a willing and able person on scene who wants to take their property. So you're saying you're going to force them to take their property with them in order to inventory it? I don't buy it. Because I can tell you one thing. If that person was a homeless person with a shopping cart full of stuff, and they had somebody with them on scene that was willing and able to take that shopping cart, I promise you, you ain't taking that shopping cart, right? You're gonna let it go. So why is it any different? Oh, but Anthony, a shopping cart is too much stuff versus just a bag. Well, you get down to the nitty gritty. You're still not giving a community caretaking rationale. People can give up their stuff to other people. So I'm just letting you know that is the dirty little secret here of the problem that we have here with, you can say, well, business as usual, we'll just do an inventory. Yes, 99.9% of the time, that's exactly what you're going to do. But there will be a situation where, as I described, where you are likely, in my view, going to have to give the backpack over to somebody who's on scene, who's willing and able to take it, and so forth. Oh, but Anthony, there could be drugs, guns, and so forth. Woulda, coulda, shoulda. We don't get to search people's stuff just to make sure they're complying with the law. We have to have crew, either their consent, a recognized exception, or a warrant. Okay, if you have questions about this or anything else I teach, please leave it in the comments. I'll answer it. I'll probably make another video. If you do like this video and it's helped you, you know what to do. Until next time, my friends, you stay safe.